Hey, good morning, Colorado. It is Anna Kibble, your district director. I am coming to you about something I have a soapbox about. So be fair warned. Um, as managing broker, there are a lot of different ways that we can do real estate, but there's one thing that I think we don't have enough information and clarity about for our business. And so I want to share with you. I want to share with you my take on our seller's property disclosure. Okay. Every single time that I see as an exception for the seller's property disclosure that the seller never occupied the property, I think, oh boy, right? That seller is opening themselves up for a lot of liability. Okay. So let's talk about this and let's talk about why and let's talk about when that could be a valid excuse to not provide seller's property disclosure. So a little background in this, and you can find this in the contract to buy and sell. Colorado law requires that the seller must disclose any adverse material facts actually known to them in writing through real estate transaction in writing. So my first question when I see that the seller's not going to use the seller's property disclosure form, my first question is, okay, so then how are they going to deliver their knowledge of adverse material facts? What's the tool they're going to use? Are they going to draft an email? How are they going to deliver this in writing? Okay. So that's my first question. Okay. How is the seller going to deliver those adverse material facts? Because here's the reality. I'm going to look at the seller's property disclosure form. Even if they've not ever occupied the property, there are probably still things that they know and can complete on the seller's property disclosure form. Okay. So the two biggest reasons I hear that a seller has not completed the disclosure form is the first is that this wasn't their property. Maybe they're the executor of the estate or the trustee, and this was a family member's property, and they've never actually stepped foot in this property. They've no knowledge of what has happened in this property. Um, maybe they even live in another state and they're dealing with the entire transaction remotely. So in that case, they may not have knowledge about some of these things as an occupant of the property, but perhaps they have knowledge of some things that have happened since they've taken ownership of the property. Perhaps they have knowledge of some things that they've done to prepare the property for sale, even through a proxy like a property manager or a contractor or their real estate agent, right? So maybe they have knowledge of some of those things. Maybe they have knowledge of things like the water provider or the Metro District information or the HOA information, right? Those are other things that can go in the seller's property disclosure form. Also, the seller's property disclosure form allows for a different type of disclosure. This is disclosure by omission. So if I'm looking at the screen here, and let's say I'm unaware if there is aluminum wiring at the property, okay? Utilizing the seller's property disclosure form and leaving this blank says that I am unaware of the existence of aluminum wiring at the property. This is the type of disclosure that without using the form is incredibly difficult to do. If you're just disclosing facts about the property via, say, an email, then disclosure doesn't happen via omission. And it's questionable whether or not you know that there is an existence of something like aluminum wiring. Okay, so using the disclosure form, even when that seller has never occupied the property, allows for that disclosure via omission. Okay. Now, the other reason I hear about not using a seller's property disclosure form is, well, this was tenant occupied. They were an investor. They've never actually lived in the property themselves, but they knew someone who did. or their property manager knew someone who did, they know of what has happened during their tenure of ownership in that property, whether they occupied that property or not. They know if the furnace went out one winter on their tenants and they had to replace that furnace. They know, right? They know if their tenants flooded the upstairs bathroom and had lost their deposit due to those subsequent damages. They know about those things on the property. And the seller's property disclosure now has space for them to notate their occupation of the property. And then once again, your investor clients benefit from disclosure via omission, right? If they really don't know if there's ever been damage due to termites, other insects, birds, or rodents, well, they can leave that blank. And that's the same as saying, I don't know, right? Which is a really powerful thing. Remember, disclosures are designed for protection. They're designed to protect your seller, right? Because if they fill out this form and disclose what they don't know, right? Even if the entire form ends up being blank because they just simply don't know, that is checking the box. They have disclosed the known material facts on the property. Right. So the second use of these disclosure forms is to provide information to the buyer. But the first use is to protect the person who is completing that disclosure, right? Protecting the seller. Okay. So now let's look at it from the other side. Maybe I'm representing the buyer, and I would like the seller to provide a seller's property disclosure form, right? Who wouldn't? Who wouldn't? Here's the most important thing that I need to do as a buyer's agent, and also I should be aware of this as a listing agent. If I put a date here on the contract to buy and sell for the seller's property disclosure deadline, right? If there is a date here, then a seller's property disclosure must be provided. If there's no date here, then the buyer is not requiring a seller's property disclosure. So let's say you took everything I just said with a grain of salt and you're like, you know what, Anna, okay, fine, whatever. Seller's not doing a seller's property disclosure. Okay, listing agent, if there's a date here, then you need to counter or amend that date to remove it. Otherwise, the buyer is able to terminate for not receiving that seller's property disclosure, and your seller is in default if they are not providing it. Okay, so remember that they still need to provide that written disclosure, even if they're not using the seller's property disclosure form. Which brings me to the exclusive right to sell. When we look at the exclusive right to sell, obviously we have a section here for seller's obligations. And the very first one says the seller agrees to or does not agree to provide that seller's property disclosure form. If you're having this conversation with your seller and your seller does not agree to provide the seller's property disclosure form, okay, you can't force them to. Okay, they're going to agree or they're going to disagree. However, you need to let them know Colorado law says you still need to provide written disclosure. And if you're not using this, commission approved seller's property disclosure form, then I need you to seek legal counsel regarding how you'll disclose adverse material defects regarding the property. So here's the deal. If your seller's not going to complete the seller's property disclosure form, okay, that is okay. They have the opportunity to do that. But you should be advising them to seek legal counsel, because not completing that form and not disclosing known material defects can have legal consequences, and they should be fully informed before they make that choice for themselves. I hope that this brings some clarity around this conversation for you, what you can expect and not expect. Here's another thing that might happen as a buyer's agent. Okay, as a buyer's agent, your buyer may request that seller's property disclosure form, and the seller may refuse to provide it. Okay, you're then at a crossroads, right, where your buyer has to decide whether or not they want to move forward with that property without that property disclosure form. And if they don't, right, then by the deadline on the calendar, or if they are not delivered that seller's property disclosure by the deadline on your dates and deadlines grid, you can terminate the property for seller's property disclosure, get your earnest money back, buyer can move on to another property. However, if the seller decides not to provide that seller's property disclosure form and your buyer decides to move forward, that's it. That's it. You can't force the seller to provide that disclosure. Your buyer is then moving forward without that information. And you know what? That might be okay with the buyer and it might not. They should probably seek legal counsel if, to help make that decision moving forward. All right. Questions, comments, anything else about the seller's property disclosure? I could talk about this all day long. Give me a call, book a time to chat, CO dash